Welcome to the Companies Act 2013 and SEBI Regulations Masterclass by Corporate and Securities Law Compass. In this masterclass, we study the Companies Act 2013 chapter by chapter and SEBI regulations, regulation by regulation, with a strong focus on practical understanding and corporate compliance. Our objective is not to simply read the bare act or engage in excessive theoretical discussions. Instead, we will understand every provision through practical questions and answers, compliance checklists, drafting formats, case laws, real life corporate scenarios, and practical issues faced by companies and professionals. In this session, we begin Chapter 5, Acceptance of Deposits. This is one of the most important chapters of the Companies Act 2013, as it regulates how companies can raise funds through deposits while ensuring adequate protection for depositors. Throughout this chapter, we will understand the legislative intent behind the law, the practical compliance requirements, the Companies Acceptance of Deposits Rules 2014, common compliance issues, penalties for non-compliance, and important judicial decisions. So let's begin with Chapter 5, Acceptance of Deposits. Before we study the provisions of the Companies Act 2013, it is important to understand the legislative background that led to its enactment. Following India's economic liberalization in 1991 and the rapid transformation of the corporate sector, it became evident that the Companies Act 1956 no longer adequately addressed the needs of a modern and globally integrated economy. At the same time, countries such as the United Kingdom, Australia, New Zealand, and Canada had already undertaken comprehensive reforms of their company laws. The government had earlier attempted to replace the Companies Act 1956 by introducing new company bills in 1993 and 1997. However, these efforts did not culminate in a new law. Accordingly, the Ministry of Corporate Affairs constituted the Expert Committee on Company Law on December 2, 2004, under the chairmanship of late Dr. J. Irani, who was then the director of Tata Sons. The committee was entrusted with reviewing and modernizing the Companies Act 1956 in line with global best practices and the evolving needs of Indian industry. The committee recommended significant reforms relating to corporate governance, establishment of the National Company Law Tribunal and the National Company Law Appellate Tribunal, independent directors, audit committees, mergers and acquisitions, investor and depositor protection, financial reporting, e-governance, and ease of doing business. These recommendations served as the basis for the company's bills introduced thereafter, and many of them were ultimately incorporated into the Companies Act 2013, including provisions relating to one-person company, NCLT and NCLAT, corporate governance, audit committees, independent directors, mergers, enhanced disclosures, and investor protection. Therefore, the J. Irani Committee is widely regarded as the policy foundation of the Companies Act 2013, as it laid the groundwork for India's modern corporate law framework. This legislative background helps us understand not only what the law provides, but also the policy objectives behind its enactment. Before we study the provisions of Section 73, it is important to understand why Parliament introduced this provision. Understanding the legislative intent helps us appreciate not only what the law says, but also the purpose it seeks to achieve. 1. Restrict acceptance of deposits from the public. The first objective of Parliament was to restrict companies from freely inviting, accepting, or renewing deposits from the public. Under the Companies Act 1956, companies could accept public deposits subject to regulatory requirements. However, over time, concerns relating to defaults in repayment and protection of depositors highlighted the need for a stronger legal framework. Therefore, the Companies Act 2013 adopted a more restrictive approach by generally prohibiting public deposits except where specifically permitted under the Act. 2. Permit deposits from members subject to statutory safeguards. At the same time, Parliament did not impose a complete prohibition on deposits. Companies are still permitted to accept deposits from their own members, but only after complying with the safeguards prescribed under the Act and the Companies Acceptance of Deposits Rules, 2014. These conditions ensure that deposits are accepted in a transparent, regulated, and responsible manner. 3. Protect the interests of depositors. Another important objective was to strengthen depositor protection. Parliament intended to ensure that companies provide proper disclosures, maintain financial safeguards, and comply with prescribed conditions before accepting deposits. These safeguards enable depositors to make informed decisions and reduce the possibility of misuse of their funds. 4. Ensure timely repayment of deposits and interest. Section 73 also seeks to ensure that companies honor their commitment to repay deposits together with interest within the agreed time. Deposits should not become a permanent source of finance. Timely repayment strengthens public confidence in the corporate sector and promotes financial discipline among companies. 5. Provide an effective legal remedy. Recognizing that depositors should not be left without protection in the event of default, Parliament empowered the National Company Law Tribunal to intervene. Where a company fails to repay the deposit or interest, the tribunal may order repayment and, where appropriate, award compensation for any loss or damage suffered by the depositor. This provides an effective statutory remedy to protect depositors' interests. 6. Promote financial discipline and good corporate governance. Finally, Section 73 is intended to promote responsible corporate behavior. By prescribing eligibility conditions, compliance requirements, and accountability mechanisms, the law ensures that only companies capable of fulfilling their obligations are permitted to accept deposits. This strengthens corporate governance, enhances transparency, and builds confidence among investors and depositors alike. In summary, the legislative intent behind Section 73 is not merely to regulate deposits. Its broader objective is to protect depositors, regulate fund mobilization by companies, ensure timely repayment, provide effective legal remedies in cases of default, and promote financial discipline and sound corporate governance. Now that we understand why Section 73 was enacted, let's move on to the statutory provisions and examine them clause by clause. Before we understand Section 73 of the Companies Act 2013, we must first understand Section 58A of the Companies Act 1956. Let me ask you a simple question. Did the Companies Act 1956 prohibit companies from accepting public deposits? The answer is no. Section 58A did not prohibit public deposits. Instead, it regulated how companies could invite and accept deposits. The central government, in consultation with the Reserve Bank of India, was empowered to prescribe the limits, conditions, and manner in which companies could accept deposits from members or from the public. The objective was to balance business funding with investor protection. Companies had to comply with prescribed rules, issue advertisements containing important financial information, and satisfy repayment-related conditions. Remember this one sentence. The Companies Act 1956 regulated public deposits, whereas the Companies Act 2013 introduced a much stricter depositor protection regime. In the next slide, We will study Section 73 of Companies Act 2013. Welcome to Chapter 5 of the Companies Act 2013. Before reading even a single word of Section 73, let me ask you a practical question. Imagine you are the managing director of a company. Your company urgently needs 200 crore rupees. Instead of approaching a bank, you decide to collect money directly from the public by offering an attractive rate of interest. Can every company legally do this? If your answer is yes, don't worry, many people think the same. But after today's lecture, you'll realize that the Companies Act 2013 follows a completely different philosophy. Section 73 is not just another compliance provision. It is the gateway provision of Chapter 5. Every other section in this chapter is built upon this one. So before we analyze every word, let's first read the law exactly as Parliament enacted it. Let's read the provision slowly. Notice something very carefully. Parliament did not write just one prohibition. It used several carefully chosen expressions. It says, no company, invite, accept, renew, from the public, except in the manner provided under this chapter. These are not ordinary words. Each phrase has an independent legal purpose. By the end of this lecture, you'll understand why every one of these expressions was necessary. But before breaking the section into phrases, let's understand what the provision means in simple language. Now let's convert legal language into plain English. The general rule is simple. A company is not free to collect money from the public as deposits. It cannot invite the public. It cannot accept public deposits. It cannot even renew an existing public deposit. However, Parliament does not impose an absolute ban. If Chapter 5 itself permits a company to accept public deposits and the prescribed conditions are fulfilled, then acceptance becomes lawful. So remember this simple formula. General rule: public deposits are prohibited. Exception: public deposits are permitted only where Chapter 5 expressly allows them. This single idea is the foundation of the entire chapter. Let's start with the first phrase. Why didn't Parliament simply write "a company shall not"? Instead, it deliberately used the words "no company." Why? Because Parliament wanted every company to first assume that the prohibition applies to it. Whether it is a private company, a public company, a one-person company, or even a government company, the starting point is the same. Only after reading the proviso or any specific exemption should you ask whether your company is excluded. This drafting technique prevents companies from assuming that the law applies only to certain classes of companies. This is one of the smartest drafting techniques in the Companies Act. Think about it. If Parliament had written only, "No company shall accept deposits," companies could argue that merely advertising or extending an old deposit was outside the law. To avoid that loophole, Parliament regulated every stage of the transaction. First comes the invitation, then comes the acceptance, finally comes the renewal. In other words, the law governs the entire life cycle of a public deposit, not just the moment when money reaches the company. Notice another important expression. The law specifically says "from the public." Why? Because Chapter 5 draws a clear distinction between public deposits and deposits from members. Section 73(1) deals with the public. Section 73(2) deals with members. So before applying any provision in Chapter 5, ask yourself one question. Who is providing the money? That answer determines which provision applies. This phrase is extremely important. Parliament never said no company shall ever accept public deposits. Instead, it created a general rule together with controlled exceptions. That means the law first prohibits acceptance, then elsewhere in Chapter 5, it tells us when, how, and subject to what conditions a company may accept deposits. This drafting balances two objectives: protecting depositors and allowing genuine business financing where appropriate. Now let's read the proviso. Does Section 73(1) apply to every company? No. Parliament itself excludes three categories. First, banking companies. Second, non-banking financial companies regulated under the Reserve Bank of India Act 1934. Third, any other company that the central government may specify after consulting the Reserve Bank of India. Why are these companies excluded? Because they already operate under specialized financial regulatory systems administered by the RBI and other financial regulators. Applying Chapter 5 in the same manner could create overlapping regulation. In our previous slide, we learned that Section 73(1) generally prohibits companies from accepting deposits from the public. Now, a natural question arises. Does that mean a company cannot accept deposits from anyone? Think about a closely held private company. Its shareholders trust the company. Can the company accept money from its own members? The answer is yes. But Parliament does not give a blanket permission. It says you may accept deposits from your members, but only after complying with strict statutory safeguards. Those safeguards are contained in Section 73(2). Today, we will understand not only what the law says, but why Parliament imposed these conditions. Let's first read the opening part of Section 73(2). Notice something interesting. Parliament has changed its language. In Section 73(1), the law began with "No company shall." That was a prohibition. But here, Section 73(2) begins with "A company may." Why? Because Parliament is now granting a conditional permission. It is saying, yes, you may accept deposits from your members, but only if you satisfy every condition laid down in the Act and the rules. One missing condition can make the acceptance unlawful. Let's simplify the provision. Section 73(2) does not create an unrestricted right. Instead, it creates a regulated permission. A company can accept deposits from its own members only after following the statutory procedure. In other words, membership alone is not enough. Compliance is equally important. This reflects Parliament's intention to protect members even though they are insiders of the company. This is the first question every student should ask. Why does the law permit deposits from members but restrict deposits from the public? Because members voluntarily become part owners of the company. They have voting rights, they receive financial information, they participate in general meetings. The general public does not enjoy the same level of access or control. Therefore, Parliament considered members to be relatively better informed than outside investors and allowed companies to accept deposits from them, but with safeguards. Now, another question. If the board of directors manages the company, why involve the members? Why insist on a resolution in the general meeting? Because accepting deposits creates financial obligations. The money belongs to members. The repayment obligation affects the company's future. Parliament therefore wanted this decision to receive approval from the collective body of shareholders rather than from the board alone. This promotes transparency and accountability. Notice another interesting phrase. The Act says the rules are prescribed in consultation with the Reserve Bank of India. Why involve the RBI? Because accepting deposits is not merely a corporate law issue. It is also a financial stability issue. The RBI has extensive expertise in regulating deposits and protecting depositors. Therefore, Parliament ensured that the Companies Act and RBI's regulatory experience work together. If members are already shareholders, why impose so many conditions? Because even members can suffer financial loss. History has shown that companies sometimes default in repaying deposits to their own shareholders. Parliament therefore introduced safeguards such as approval in the general meeting, compliance with the deposit rules, repayment reserves, disclosures, filing requirements, and other statutory conditions. The objective is simple: protect the members' money while allowing genuine business financing. If you remember only one concept from today's lecture, remember this. Section 73(2) is not a provision granting unrestricted freedom. It is a carefully designed permission. Parliament wanted companies to raise funds from their own members where genuinely required. At the same time, it wanted to ensure that members' hard-earned money was protected through statutory safeguards. That balance between business flexibility and investor protection is the real philosophy behind Section 73(2). Let's revise today's discussion. Section 73(1) says no to public deposits unless the law permits. Section 73(2) says yes to deposits from members, but only after satisfying the prescribed conditions. Those conditions are not optional. They are mandatory safeguards designed to protect members and promote responsible corporate governance. Before you leave, let me ask you one final question. Suppose a private company wants to accept 50 crore rupees from its own members. Can it simply pass an ordinary resolution and start collecting the money? Absolutely not. Section 73(2) gives permission, but only after complying with a series of mandatory legal conditions. What are those conditions? Why are they so important? What happens if even one condition is ignored? And how do these requirements work in actual corporate practice? We'll answer all these questions in the next lecture, where we'll decode each condition of Section 73(2) one by one, along with the company's Acceptance of Deposits Rules 2014, practical examples, compliance checklists, and examination tips. Until then, don't just memorize the law, understand the legislative intent behind it. Because once you understand the purpose, remembering the provision becomes effortless. I'll see you in the next lecture. Welcome to Corporate and Securities Law Compass. I am a member of the Institute of Company Secretaries of India, ICSI, and currently serve as a company secretary. The views, opinions, interpretations, and explanations shared on this channel are strictly my personal views and are provided solely for educational, academic, and informational purposes. The content published on this channel does not represent the views, opinions, policies, or official position of my employer, any company with which I am associated, any client, or the Institute of Company Secretaries of India, ICSI. All examples, case studies, and discussions presented on this channel are based on publicly available information, applicable laws, statutory provisions, judicial pronouncements, regulatory materials, or are purely hypothetical for educational purposes. I do not disclose, discuss, or use any confidential, unpublished, or proprietary information obtained through my professional employment. I fully comply with the SEBI Prohibition of Insider Trading Regulations 2015, the Companies Act 2013, applicable laws, professional confidentiality obligations, and the internal policies of my employer. Nothing contained in this channel should be interpreted as the communication, disclosure, or use of unpublished price-sensitive information (UPSI) or any information that may violate insider trading laws or other legal obligations. This channel does not provide legal, tax, investment, financial, accounting, or any other professional advice. The content is intended solely for educational and informational purposes. Viewers should consult qualified professionals before making any legal, business, compliance, taxation, accounting, or investment decisions. Although every reasonable effort has been made to ensure the accuracy and reliability of the information presented, laws, rules, regulations, circulars, and judicial interpretations are subject to amendment and change. Accordingly, neither the presenter nor this channel shall be responsible or liable for any loss, damage, liability, or consequences arising from the use of or reliance upon the information provided. All company names, trademarks, logos, and brands belong to their respective owners and are used only for educational, news reporting, review, and commentary purposes. Copyright Corporate and Securities Law Compass Navigating Law with Clarity. All rights reserved. By accessing or viewing this channel, you acknowledge that you have read, understood, and agreed to the terms of this disclaimer.